ask questions during the webinar, and we will answer them as we're proceeding through. What is happening in Colorado is representative of what's going on around the country. Our country is facing a national security crisis of unimaginable proportions right now. In our opinion, federal and national business leadership is not moving fast enough to deal with this problem, so it's good to see state governments starting to move. A little bit more about that momentarily. Today, you've got two great speakers today that come from two organizations that are putting on this event. Danielle Urban, partner at Fisher Phillips, a national law firm, and Mitch Tannenbaum, partner and director of IT for Cybersecurity LLC, firm headquartered here in Denver, Colorado. First, some information about Danielle. Danielle is a partner in the Denver office of Fisher Phillips. She is a CIPP. That stands for Certified Information Privacy Professional. She advises clients on data privacy and security issues. That is an extremely important skill set today, especially combined with her legal education and experience. We've been working with Danielle on several projects over the last year, and I can tell you that we have the highest respect for her and her knowledge of privacy and security matters. It's an honor to be associated with her and Fisher Phillips. Now, some more information about Mitch Tannenbaum, who will lead today's event. Mitch is a humble guy and would never tell you the things I'm about to tell you, but they're true and worth mentioning. Mitch has been a cybersecurity professional for over 30 years. He started his career as a coder and IT professional, and then started working for Texas Instruments in Texas, which was doing sensitive work for the Department of Defense. Mitch was quickly identified as a rising star, and he was tagged to set up the cybersecurity program for Texas Instruments that had thousands of engineers and other personnel who had to learn how to protect sensitive data. After this work, Mitch moved into the financial services space, specifically the mortgage lending industry, where Mitch worked for a couple of large mortgage lending back office operation companies that service all the big banks like Wells Fargo's and other. Today, mortgage lending is a big part of our company's business, and Mitch is recognized nationally as the leading cybersecurity professional for that industry. After his mortgage lending stint, Mitch opened his own consulting firm, and he and I merged our companies 3 years ago. One other important area of expertise. Mitch is an expert in cybersecurity regulations and standards and compliance issues. Graham Leach Bliley, the New York Department of Financial Services regulation, the NIST 800-171 regulation that covers DoD subcontractors, the ISO 27001 standard, and of course the new Colorado law you're about to hear about. And he has an almost photographic memory, which allows him to recall facts and details in an amazing way, and for me, irritating, quite frankly. He's so smart. And finally, he does not speak tech. He speaks English. You will understand everything he is about to tell you. You're in for a treat. At this time, I turn the event over to Mitch and Danielle.
Thank you, Ray, for that flowery introduction. And Ray is certainly right. I would not say those things about myself. So thanks for doing that. So today we're going to be talking about the new Colorado law. Please feel free to submit questions in the question box on your GoToWebinar, and we will attempt to answer those as we go. So the Colorado law has been represented as a landmark law in terms of cybersecurity legislation in the United States, and I'll explain why during the course of the webinar. But I think for businesses that are based in Colorado and businesses that do business in Colorado but aren't based here, because it affects both of those groups of people, it is a new age, and it requires some changes in terms of how people think. I'm going to spend a large chunk of today's webinar talking about recommended actions in terms of things that organizations need to do in order to be in compliance with the regulation. So with that being said, I'm going to move forward. The bill has moved pretty quickly. So one of the things we see a lot of times is bills literally do not make it through the legislative session and have to be reintroduced in multiple years. This bill was introduced in January. There were 6 very quiet, unpublished versions. and it was signed by the governor last month. So between January and May, about 4 months. One thing which is pretty impressive and almost never happens in legislatures is that there was not a single no vote on the final bill. So there was 100% participation in terms of people endorsing this bill. And the bill becomes effective on September 1st. What we are seeing nationally is a trend in terms of increased cybersecurity and privacy legislation throughout the country. And in fact, 20% of the states have done something in this arena over the last legislative session.
And I want to just add to this. Mitch said there wasn't a single no vote. I would say that getting this passed and getting it passed relatively quickly had a lot to do with businesses taking part and cooperating as well. I think everyone realized, all the parties realized how important it was to get something in place. There have been some really high profile hacks in the last couple of years, and probably all of us on this call have been affected. So this is a bill that has been vetted by key parties, and it really has some serious consequences, which we're going to discuss, but consequences that I think all of the parties were in agreement were probably necessary.
Thanks, Danielle. So with regard to this bill, one of the things that's unusual about this is that it doesn't address just people that own or license personally identifiable information, and I'll talk about what the Colorado definition of PII is, which is pretty extensive. But this addresses anybody who maintains information, which means anybody who uses information, which is pretty much all businesses. And then the definition of a person is also very, very broad. It includes obviously individuals and corporations, but it also includes trusts, estates, partnerships, unincorporated associations. Basically, the objective here was to make this as broad as humanly possible, both in terms of who is covered by the law, and that's one of the reasons why this is a landmark law. So in many cases, we've seen laws where we say, if you're a financial services firm, if you're a healthcare providers, something like that, then you're covered by the law. This covers any company, any organization. It does not cover individuals doing things for themselves, but it does include individuals who are doing things for business. So for example, if you are a one-person company, you're in business for yourself, you're still covered by this. It's just a function of somebody who's doing this for a financial gain. So there are no exemptions for size or type of business at all. Everybody's covered. And what it does say is that the actions that you take have to be commensurate with the risk that your organization represents. So if you're the corner coffee shop, you're covered by the law, but other than, for example, accepting credit cards, you probably don't collect a lot of non-public personal information. On the other hand, if you are a one-person law firm, a one-person accounting firm, a one-person architectural firm, any kind of professional services firm, you are covered. One thing that's also very unusual is that, and I'll explain where later, is that it preempts HIPAA and GLBA for healthcare and financial services firms in certain aspects. That's unusual. There's also a companion set of laws that parallel this particular bill, 1181, that includes government agencies. And what we see most of the time is that the government exempts itself from any kind of regulations. In this particular case, the government very intentionally included state and local government entities in being obligated to go follow this law. So that's another place where this is a landmark piece of legislation.
Let me also say we've had a lot of inquiries in the last 2 weeks. This applies to you as a business if you fit the criteria Mitch mentioned, even if you're not based in Colorado. So that's been a question we've gotten quite a bit. Just want to make that clear to the extent that it's not.
Thanks. So in terms of who's affected, what kind of information is affected, here's a definition. I'm not going to read it, but it's a very broad definition of basically anything that can be identified with a person, any kind of ID number, and it also includes, which is a limited number of states have started to do, is biometric data. So the problem is, if somebody's using a fingerprint, for example, to identify you, there's no way to go change your fingerprints, at least not easily, if the data gets out. So we're seeing more and more states are including biometric data.
And let me also mention, on the biometric data, we just as a firm are handling a biometric data class action in another state. And it's becoming, so not only do you potentially open yourself up to consequences under this bill, but you also still have, there could be legal action taken against you in a civil suit. So it is important not only to comply with the law, but to show that you are up to date on best practices, because there's an attorney's bar out there who have become very active when it comes to class actions for data breaches. And especially biometric data has become a really hot topic recently.
And the reason, in my opinion, the reason why biometric data is such a hot topic is because you can't change it. Right? If you're right. And there's a lot of different things that we use for biometrics. One that's been around for a while is called palm geometry, where they actually measure the shape of your hand, and that's actually pretty unique, and it's used a lot in data centers. But certainly fingerprints and iris scans and retina scans and things like that are very common. And if it gets out, if it's used for authentication, meaning that all you need is that fingerprint. Think about your phone, right? If you have your fingerprint and you swipe it on your phone, that's all you need. So if that gets out, then all of a sudden that security mechanism is hard to get the genie back in the bottle. So the law says that the crux of the law here is that an organization must maintain reasonable security procedures and practices. But very conveniently, they don't say what reasonable means, and we're hoping that the Attorney General does, in fact, help define those standards, at least at a high level, like California did. They did that about 4 years ago, and what Kamala Harris did, who's the AG at the time, said, in her opinion, if you don't follow the standards in the document, which is on the California State website, then that is by de facto, that means that you are not implementing reasonable procedures. We don't know whether Cynthia Kaufman is going to do that. We hope that she will, because it'll at least give people some guidance. What you need to be able to do, and Danielle can probably talk some more about this, is whatever it is that you do, you need to be able to go off and in a court, if you get pulled into court, to be able to defend what you have done. And our suggestion is,
to defend. Sorry, Mitch, go ahead.
Our suggestion is that means use best commercial practices.
Yeah, if you're not using best commercial practices at a minimum, it will be difficult to show that you've taken all reasonable steps. And Mitch, how do you advise your clients? What's the best way to know what everyone else is doing, what best commercial practices are?
Well, I think there's a number of things. There are some organizations like the SANS Institute and OWASP who have published recommended actions, and in fact, the California Attorney General's recommendations are based on the CIS 20. So there are a number of well-known, well-accepted standards, and the second half of this presentation will really kind of go over those. So I don't think that best practices are hard to find. I think it means that people have to change the way they've been thinking about cybersecurity. And the reality is there's always an intersection between security and convenience. And if you opt for, gee, it's inconvenient to go put a password on my computer because I have to log in, yeah, okay, it's more convenient now, but it's also less secure. So, that's really where the challenge is. But I think the standards are pretty well known.
Danielle, I think one of the best articulations of best practices in the country right now is the New York Department of Financial Services regulation that's been implemented in New York. I think it's very well laid out and very clear, and pretty much anyone can understand it.
Great, thanks, Mitch. Sorry, Ray.
So one of the other things that this law requires, it requires you as a business owner to go off and ensure that third parties such as vendors and cloud providers protect PII before you share it with them. So if you have an outsourced relationship where you are outsourcing your HR system, you're outsourcing your payroll system, you're outsourcing anything, your client loyalty system, your frequent flyer system, the law requires that you in writing get your third party to go off and provide the same level of protections that you have to provide. Now, alternatively, the law does allow you to assume that liability for their bad security habits. I think that's really a really bad strategy, but the law does allow you to do that if you want to do that. And then the other part of the law is it requires specifically a written policy for the secure disposal of documents, both paper and electronic, because we've seen so many cases of on the news here locally in Colorado where people find boxes and boxes of confidential information inside of dumpsters and near dumpsters that people haven't disposed of.
And I want to highlight 2 points related to this slide. The first is related to secure document disposal. This law doesn't just affect electronic information. It's important to know that it also applies to hard copy documents, which is not always the case with data security laws in the various states. So it's important to note that. And the second piece is if you have agreements with third-party vendors, it's important to put your requirements as it relates to data privacy and security in the agreement. Because if you don't have it in writing, it's a little more difficult to show what procedures you followed and to let your vendor know what your expectations are. Also, you have someone that you can look to for indemnification if they let you down. If they're not doing what they're supposed to be doing, you've got a contract in place spelling out their obligations. It makes it easier for both sides.
That's absolutely right. The other thing which is unusual about the Colorado law is that you must notify those people who are affected within 30 days. That is actually the shortest notification period in the country for a general data breach law. There are no extensions allowed. Florida, I think, allows extensions. It has a 30-day period also, but allows extensions. There's no exception for HIPAA and GLBA, both of which have longer time. So what the Colorado law says, you can notify Health and Human Services if you're a HIPAA provider in 60 days that the HIPAA legislation requires. But if you don't notify Colorado in 30 days, you're in trouble. The only shorter notification periods are the ones at the bottom there, and they are don't really affect us DoD contractors and in the European Union. It also requires that you notify the Colorado Attorney General if the breach affects more than 500 people, and you must notify the 3 large credit reporting agencies if the breach affects more than 1,000 people. That's also becoming more common in other state laws. One of the things that's important, and we deal with this with breaches all the time, is if you are a multi-state organization, i.e. you have a website, which kind of covers most people, and you have a breach, and the breach impacts people of multiple states, you need to understand all the different people that are affected. We had a recent breach we were involved in where there was literally a handful of people that were affected, and there were 9 different reporting agencies that the client had to report the breach to. The Colorado law spells out in gory detail the specific contents that a breach notification must have. It also spells out in detail if the cost of notifying people is greater than a certain dollar value, then you have alternate notification methods. And there was a lot of discussion going back and forth in terms of people just wanted to go off and say, well, I'll put a notice on my website that's good enough. And the answer is no. This law requires a direct notification of people as long as I believe the dollar value is less than $250,000 and costs you to notify them. And then there are additional requirements if the breach is related to a compromise of online credentials, in terms of you have to specifically, you have to tell people to go off and recommend that people change their password, things like that. So, this is always good to figure out what these breach notification letters are going to say in advance. Work with Fisher Phillips as your attorney to go off and construct these things to make sure that the letters that you have are compliant with the law, because you can get in just as much trouble for sending out a non-compliant notification as not sending out any notification.
And let me say, this is all part of a data breach response plan. So if you haven't thought about it for your organization, now's a good time to think about how will you respond to a data breach in general. And to Mitch's point, having a notification drafted in advance, because it's probably not if you have a data breach, it will be when. You have it done in advance, you've vetted it with your legal team and your executive team, you know what it's going to say. And a notice like this can be used in every state. It's comprehensive enough that I can't think of a state that wouldn't find this adequate. So you have it ready to go. It's one less thing that you have to worry about in the event of a data breach, and it helps you to meet that 30-day timeline.
Right, absolutely. So there is one exception, but there's a caveat to the exception. The exception is there's no duty to notify if the data was encrypted. But in most cases, we see, for example, we saw in the Blue Cross breaches a couple of years ago, the data was encrypted, but the encryption mechanism was compromised at the same time. So your only exception is if it was encrypted and the attacker did not get the encryption keys, then in fact you don't have to notify. But that's one of those things where you're going to go off and take your incident response, which hopefully you've documented, trained, and prepared in advance, and you can go in that 30-day window, figure out whether or not the encryption mechanism was compromised as well. So one thing to consider, and people don't do this often, is if you are acquiring a company, you are acquiring a liability. The question is, do you know what that liability is? So if the company that you're acquiring has poor cybersecurity practices, you're acquiring that liability. If you're selling a company and you're not just selling the assets, are you disclosing the liability? We saw with the Yahoo breach, right, that there was the Yahoo took a very, very significant haircut and agreed to continue to be legally and financially accountable for certain of the breach costs as a result, because they didn't disclose that in a timely fashion. And obviously, if you're an investor in a company, and let's say we're in the same Yahoo situation, you thought your investment is worth something, and depending on the size of the company, if it's a small company, Yahoo, while they lost whatever it was, $50 or $100 million, or more than that, actually, a couple $100 million in terms of the sale price, they'll survive. If it's a small company and you're an investor in it, then they may well not survive.
And I want to make a note about the first bullet point, acquiring a company. We have a big, sophisticated international construction company that acquires a lot of regional mom and pop smaller companies. And I can't stress enough how important it is to do your due diligence while you're looking at acquiring those companies, because these smaller companies that this particular client is looking at doesn't even usually have an IT person on staff, or if they do, that person is pretty unsophisticated. So there are, and I have to say, I think construction in particular is an area where there have been a lot of breaches in recent years. They're particularly ripe target. So it's something that you want to look carefully at. Do some due diligence in that area.
We have some clients in the construction space, and there's also theft of trade secrets, because you have methods and processes that are proprietary to individual construction firms. And that's obviously not limited to the construction industry. Almost all industries have methods and processes. And so the breach often exposes intellectual property. And while there's not a requirement to disclose that under this law, if you lose your intellectual property, certainly it has an effect on the value of the company. And there's many, many examples of that. In terms of the consequences, the Attorney General can bring a civil action to ensure compliance or to recover damages on the part of Colorado residents. But also, and probably of more concern, is that at the request of either the local district attorney or the governor, the Attorney General can bring criminal charges. And
also don't forget, even if the Attorney General does not bring an action a compliance or damages action, you are always at risk for an attorney, an outside private attorney, bringing a suit on behalf of any of the victims of the data theft.
Absolutely. So we're going to now move on to the second half of the seminar, and we're going to talk about recommended actions. And Ray, if you're looking at the questions, please interject the questions that the audience has asked us. The first one, and probably the kind of the cornerstone of things, is to create and then implement a written information security program, or a WISP. Financial service firms and defense contractors already do this. It's part of other regulations, but other industries have not had to do that. And basically what a WISP says is, here is our overall cybersecurity program in a nutshell. And that's something that every employee needs to understand and follow, of course. And it has to be so actively supported by senior executive management.
Mitch, you asked for questions. You asked for a couple questions. First, one question everyone was asking, a lot of people were asking if a copy of this presentation is going to be made available, and the answer is yes to that. Another question has to do with how does the Colorado law complement or contrast with the EU law, the GDPR?
So it certainly complements, and I'll touch on something that's going on in California at the very end of the presentation. The EU law gives people a lot more rights. The right to be forgotten, the right to correction, the right to halt processing, the right to a copy of their data. There's all kinds of rights that come with the EU law, none of which are part of the Colorado law. The Colorado law is mostly related to making sure that people who have your information are taking the job of protecting that information seriously. That's really the kind of the crux of it.
And I would say, underlying the GDPR, one of the ideas that is certainly, I don't know that it's the reason that businesses are thinking about this, but under the GDPR, keeping the information only that you need and understanding how it's kept and where it's kept is really important. I mean, that's a key to the GDPR, and then keeping that information for only as long as you need it and then safely disposing of it. You can see some of those elements in here. I don't know that the GDPR had any influence on the Colorado law. I'm guessing it probably didn't. And I don't think it's complementary, but certainly some of those practices from the GDPR we're seeing making their way into other countries' laws, including Canada, but as well as some of the states in the US.
And just so people don't get confused here, while GDPR only affects the 28 member nations of the European Union, we are seeing a large number of countries actively working on GDPR-like legislation, because in order to be able to freely trade information between member states and non-member states, they have to have equivalent laws. So, for example, we've seen the Bahamas, which is a common place for call centers, implement a law. Brazil is fast tracking a law. There's a number of countries that have, Korea is fast tracking a law. So we're seeing a number of other countries that are going off and implementing GDPR-like legislation. So certainly looking at the things in GDPR that are in there, even though you're not required to comply with that, certainly would be a part of a good cybersecurity program.
Here's kind of a follow-up question to what you were just talking about. How can a state bill preempt HIPAA and GLBA when they are federal laws?
It's kind of interesting. So they're not preempting in the sense that they're saying that GLBA and HIPAA don't apply. What they're saying is we have our own requirement for data breach notification, and it is a more strict requirement, and there's nothing in the federal legislation which does not allow for a more strict law on the part of the state. So that's how they get away with that. And so, in some cases there is federal preemption, but this is not, privacy is not one. For example, the feds have been talking about for years some sort of federal privacy legislation, and the whole goal of that would be to preempt state law. That's never made it to the floor of the Congress, never mind getting passed. So If that happens, then that may affect things. But right now, I'm not counting on that happening anytime soon. Second recommendation is to designate a responsible individual for managing your information security program. That doesn't necessarily need to be a technical person. It's a person who is in charge of herding cats and making sure that everybody is doing what they're supposed to be doing and the things that need to be implemented are being implemented. So that's a project manager. Certainly having technical skills and security skills are good, but you can go off and we do this for a number of firms. We outsource the technical component to us of that, and the people inside the company are responsible for the implementation.
And I would also recommend that you have someone in that position having a high level of reportability. So you don't want a lot of managers between that person and the highest executives, because you don't want your program watered down because someone thinks it's too burdensome, or someone at a lower level who doesn't understand the consequences thinks it's too burdensome. You want to have that person reporting to someone at the very highest level so that there isn't a whole lot of undue interference with that person's recommendations about what needs to be done on the security front.
Absolutely. And we see that specifically with certain laws like GDPR and the financial services laws, GLBA, where it actually says that specifically that it has to report to executive management, because ultimately executive management is the one who's going to go off and get hauled into court. And so if they come back and say, gee, we didn't know, that's probably not a really good defense. Third recommendation is to conduct a cyber risk assessment at least once a year. The purpose of that, and you want that to be a very broad instrument. It doesn't need to be very deep. It needs to be very broad. It needs to cover the entire organization. It needs to cover everything from healthcare information, if you have some of that, and you'd be surprised the number of people who have healthcare information that they don't think about it until we do a risk assessment, to credit card information, to confidential corporate secrets, trade secrets. You want it to cover the entire waterfront, and you want to get a set of recommended actions, and then you need to go put together a plan of action to go off and say, here's what we're going to go do to go mitigate that, because it's I can tell you from a class action standpoint, if you're in a position where you had a set of recommendations, you did a risk assessment, you had a set of recommendations, and then you ignored them, and then you have a breach, that's a real problem in terms of defending yourself.
And all of that information is discoverable unless you have discussed this and your emails and your communications are in the presence of a lawyer. So keep that in mind. You want to be careful that you're giving a lot of your internal conversations around this the kind of privilege that it might deserve. Now, I'm not suggesting that everything is privileged, but all of that information is opened up to discovery, and Mitch is right that it can be detrimental if you've had recommendations that you chose not to follow, or you disregarded reports of a problem early on.
One more quick question. I'm not going to interrupt you constantly, but we have a lot of questions.
That's fine.
Regarding that 30-day breach reporting requirement question here, is that from the date of the breach or from the date of the discovery?
The date of discovery. So, many times, it takes a while, and I will tell you, we've seen the average, and the numbers vary, but the average numbers we've seen is between the date of first infiltration and the date of discovery is nationwide. The numbers typically are around 270 days. That's a long time. People can do a lot of damage in 270 days. So what you want to do is you want to work to go build controls inside of your system. We have one client who's in financial services who recently had a breach. The breach was detected at 6:30 a.m. on a Monday morning, and before 9 a.m., which is 2.5 hours later, it was confined, identified. The content that was exfiltrated was known, and the breach mechanism was closed. 2.5 hours, and we're working with them to shorten that. They have decided that number is too long. So there's a kind of a benchmark of what best practices. You're asking what's best practices. 2.5 hours is a good number. to be able to go do all that, that requires that you have all these processes in place. If you don't have these processes in place, then you'll never be able to pull that off in even in 30 days. Training, and we see companies really skimping on this, but the employees really are the first line of defense. What we've seen a lot of organizations historically is they show this really bad video that was developed 20 years ago, and they do it in a dark conference room right after lunch once a year, and they call that security training. Well, the reality is that doesn't do anything in terms of improving security. The empirical evidence is that people forget a lot of what you've taught them within 30 days. So what you want to be doing is, we have a client, for example, who requires employees to take one 30-minute training session every single month. And then part of that is also putting together an active phishing program to go off and phish your own employees, because that's phishing is likely the most common vehicle. And there are now tools that are very affordably priced to go off and do that.
Yeah, there are organizations that can help you and set up a program like that. And I would say, especially in the spring, the first quarter of each year, we see a market increase in employees falling prey to phishing scams to get W-2 information on employees. And it still happens every year, despite the fact that everyone knows that it's happening. And that, I can't stress enough the importance of training employees, because they're your first line of defense in something like that. And 5 employees might delete the phishing email, but all it takes is one to turn over those 10,000 or 20 W-2s, and then you have a problem on your hands.
And worse yet, if one employee clicks on a link and infects their computer and then infects your network, and the hackers are smart, they're just going to sit there very quietly, biding their time, wandering around your network, looking for things. And there's going to be, unless you are actively monitoring things, there's going to be no outside evidence, right? When someone goes off and sends the W-2s to somebody else, that's pretty clear. We know that happens. But if a hacker just gets in there and sits there quietly looking around, which they do, the whole discovery process, you are not necessarily going to see that if you are not looking for it. Action number 5 is to create a disaster recovery plan. And we've got one client we're working with right now. I said, yeah, we created one 3 years ago. We've never done anything with it. That's not a disaster recovery plan. That's a piece of paper that someone wrote to think that they're going to be in compliance. That will not help you recover from a disaster. Paired with that is creating an incident response program and team and test, so that you are able to respond to an incident. Danielle talked about that a few minutes ago. So an incident response program means you've got policies, you've got procedures, you've got people assigned, and the incident response team is likely going to include outside people. It's going to include people like your lawyer, your legal team. It's going to include people like crisis communications. We've seen this many, many times where Equifax is the perfect example. Huge company, mega company, and you'd think that they would have their act together with regard to crisis communications, and they just did. They actually sent people to a hacker's website accidentally in some of their tweets, because they didn't have their communications figured out, scripted out in advance. So they went off and sent people to the wrong website, and you've got to test that. So staff it, train, and test.
And let me say, if you have written plans for any of this, speaking from a legal perspective, the only thing worse than having written plans are written plans that you don't follow. So make sure that you have a written plan that's workable, that you can follow, and then in a time of crisis, everybody knows how to access that plan. Everyone knows that there is a plan, and they know to follow it, and make a note of any deviations and why you're doing it. Because if you have a plan that you don't follow, that's going to be evidence that could be used against you potentially in a private lawsuit.
Absolutely.
Good point. One more question, Mitch. We are a small company spread out all over the country. All our data is stored in the Google Cloud. Just how secure is that? Our concern is employee data stored in the cloud.
So the answer is the cloud is not good. The cloud is not bad. as is the case with storing things locally inside your own organization, it's really what controls you have put in place to go off and protect that information. That means how you train employees, how you protect the end computing device, and nowadays what that end computing device is really almost unknown. It's personally owned phones and tablets. It's home computers, because you can access the Google Cloud from anywhere. So now it's really a function of how you've gone off and built the overall security picture. So I would say that the cloud is not the villain, but lack of planning is definitely a villain. So part of your written information security program should talk about what are the security measures we're going to put in place to go off and make sure that we protect the stuff that we stick in the cloud. Everybody sticks stuff in the cloud, whether it's the Google Cloud, the Microsoft Cloud, the Amazon Cloud. And we've seen breach after breach after breach in the Amazon Cloud, and I can't recall a single one of those that have been a result of bad technology on Amazon's part. They have all been how people have implemented things. Number 7 is encrypting data. There's not a legal requirement in the Colorado law to encrypt sensitive data. There is if you're a healthcare provider, if you're a defense contractor, if you're a financial services provider. But as a general law, there's not a legal requirement to do that, but it sure makes things a whole lot safer. So one of the biggest risks is people losing phones. I saw a statistic a couple of years ago that said that there is a cell phone that is lost in somewhere in the United States every 3 minutes. If that cell phone is not protected and there's sensitive data on that, and most people get email on their cell phones, so most all cell phones have sensitive data on them, then that is a potential breach. But the end user computing devices, meaning laptops and tablets and phones, all need to be encrypted. Even your network servers should be encrypted. Data in the cloud should be encrypted. And one of the things that you ought to be asking your cloud providers as part of your vendor risk management program is, tell me about your encryption mechanisms in the cloud, so that if an unauthorized person gets access to your system, are they going to be able to see my data? So we have been pretty good at encrypting things in motion. That's what the padlock, in terms of what we see in the padlock of a website, but encrypting things at rest is still, some people do it, some people don't. This is especially important for smaller companies. Larger companies do a better job, not a great job, but a better job of restricting access to those people that have a need to know for the particular piece of data. So if you have somebody, for example, that needs access to HR data, then you should be able to, in your systems, grant them access to that, but not to anybody else who doesn't have a need. And oh yeah, by the way, when that person leaves or changes jobs, you need to be able to go off and say, this person no longer needs access to that. So managing access controls, especially as data is scattered around the cloud, is a challenge, but it's critical to be able to go off and stop it. We just saw with the case of Tesla, where we had an engineer who quit and left software running behind after he quit, and he stole gigabytes worth of proprietary trade secrets, and in fact even tried to sabotage their internal control system. So the insider threat is a very, very real threat, and it's a weak spot for most organizations.
Oh, great cybersecurity guru. Here's one more. Our website uses live chat operators to collect leads and refer customers to the proper internal staff. This is a third-party company, and to my knowledge, they do not encrypt the text traffic between their operators and our customers. Would this be a potential violation of the reasonable effort, quote unquote, portion of the Colorado bill?
Well, certainly I would say the answer to that question is it depends on what they are collecting. If they're collecting certainly a name, an email address, and a phone number would qualify as personally identifiable information. So, the real question is, are they collecting anything even more sensitive than that? Certainly, I would go back to the vendor and say, hey, and I'm assuming that, you know, likely this person is not only doing business in Colorado, but you have business in other states. So, gee, we have other state laws to go consider. That would certainly be a recommended best practice for that data to be encrypted, yes. Well, that was an interesting lead into number 9. So this question says, or this recommendation says, you ought to have a data classification and document marking program. How do I know what information is classified at what level? So if you think about for people who've been around the military world, they have things like secret and top secret and confidential, you know, and there's a whole program about how things get classified in those different levels, who's allowed to classify them, how you have to mark them. Well, in the corporate world, we have things like corporate proprietary, corporate trade secret, which, by the way, once it gets loose in the wild, is no longer a trade secret. You have personally identifiable information. You may have sensitive information, would be things like healthcare information. So you may have, and the other thing you have, of course, is information that belongs to your customers. So you have this small number of different categories of data classification, but you should create a data classification policy and procedure and a marking policy and program, so that anybody who sees this information, whether it be a screen on a website that's marked, or whether it be a video, or whether it be a Word document, you know, everybody knows that, you know, here's the markings to look for, and here's what those markings mean.
Here's a question for Danielle. It looks like, can employees submit anonymous complaints against an employer with respect to this law? And who is criminally liable, the company or the CEO?
Well, so I'm not sure if the person asking the question is asking if the complaint can be submitted to the company or the Attorney General. I mean, certainly you can always, most big companies have a mechanism for submitting anonymous complaints. Medium-sized and smaller companies don't necessarily, but there is nothing to stop an employee from submitting a complaint that falls under one of these categories. And you're protected by the law from retaliation if you have a good faith belief that a violation of this law occurred. Now, if you're asking if there's a mechanism to report it, a statewide mechanism or a government mechanism, I don't know that there is. You know, I'm sure if someone made a complaint to the Attorney General's office, that complaint would come back to the company, and the company might be asked to investigate. You know, I don't really know the amount of resources that are going to be allocated to enforcement of this bill. So it's hard to say right now, but I have no doubt that if a complaint is submitted to the Attorney General's office, they will probably have a way to get back to the company and say, someone submitted this complaint, we need you to look into it and report back to us. And in terms of criminal penalties, I guess it depends who's going to be personally at fault, who actually didn't do something, and it has to go beyond negligence for there to be criminal liability, who intentionally disregarded the law, who did something that violated the terms of this law. And so it's hard to say in this situation without having a specific set of circumstances who might be held criminally liable. But criminal liability comes down to individuals in a situation like this.
Next recommendation is to implement a security event logging and auditing system that's appropriate to the risk. You know, what our client, excuse me, who just was able to go off and detect and respond to the incident in 2.5 hours, was able to do that because they got alerted immediately as soon as an inappropriate action occurred on the part of an attacker. If you don't have a security event auditing system and alerting system, you will never, ever, ever be able to go achieve that. And the next thing, and I think it's the last thing, yeah, it is. Last thing is to create a third-party cyber risk management program. We have many organizations that we're involved in have a third-party vendor risk management program. What we're looking at is licensing and compliance and insurance and right to do business in a state and things like that. That's not cyber risk. Now we're adding cyber as a component to the overall vendor risk management program. If you're not doing that, because, and especially because it explicitly says that you are required under the new Colorado law, which goes into effect September 1st, to go off and document that the vendor has agreed to assume that liability. If you don't have a vendor cyber risk management program, how are you going to do that? How are you going to go evaluate whether that program that the vendor has in place is adequate to meet the definition of the Colorado law? There's a lot here. Here's a link to the actual bill itself. It's not that long, but there's a lot of meat to it. And so, you know, if you're interested, certainly you can go do that. Just a quick note on 2 other states. Oregon just passed a law. They increased the scope of PII, who is covered, and they shortened notice, in their case, 45 days. And they basically called Equifax on their BS for requiring people, in order to get the free credit monitoring, to give them a credit card. They can't get a credit card. They can't require them to provide a credit card. And there's a ballot measure that is likely to be on the ballot in California in November that looks a lot like GDPR. Now, there's going to be a massive fight on both sides of the equation for that. They think that there's going to be like literally $100 million spent on this particular ballot initiative. So we don't know what's going to come there. That will have a huge effect on the landscape, assuming that passes. And many other states are tightening their laws as well.
And let me just make a note about the GDPR. We've been talking about that a lot today, assuming that people know what it is. It's a general data protection regulation that went into effect May 25th of this year. And up until the last couple months, I'd say a lot of the employers, businesses we work with had not really paid much attention to it. And then we all started to get privacy notices in our email and spam filters, and people started asking questions and realized that it had implications for a lot of us, even though we're US based. So if you think that you might be affected by this, let us know. If you have any interest in a GDPR webinar, if you'd like to learn more about it, let us know that too. We certainly don't want to give people information they don't want on this webinar, but if it's something that you think you and your organization can benefit from, let us know.
Absolutely. So, I mean, it's not easy. It's definitely worthwhile. It's definitely doable. And if you're, especially if you're a small business, that, you know, we talk about that, you know, what do I do? We have a business cybersecurity certification program. This is the only ad in the webinar. It certainly, in terms of the number of business, 95% of businesses are small businesses. This gives you a great level of protection. It gives you policies and training and procedures and incident response and disaster. It gives you all those things. And it also includes hands-on support from our team. So if you're interested, you can just Google Business Cybersecurity Certification Program and find more information about that. And we still have a few minutes if there are any more questions, Ray.
Yeah, what happens if a vendor makes recommendations based on best commercial practices and a firm does not follow the vendor's suggestions? That's not, I don't think that's worded exactly, you know, where it fits the situation, but you'll get what they're asking about right there, Mitch.
Well, I think Danielle said that before, right? If there were recommendations that were made to go off and improve the organization's cybersecurity, and the organization chose not to go off and follow those recommendations, then you better have some logic that you think you can justify in court for why it was you decided not to do that. If you just decided not to do that because, gee, it sounds complicated, or maybe it's expensive, or I don't want to change the way I'm doing things, you know, that's not a very good justification. And if you wind up in court, either because the Attorney General took you there or because of a civil lawsuit, that's going to be very hard to defend. You know, that's why you know, sometimes lawyers get involved in these processes so they can go off and craft a response to go off and say, yes, here's our strategy, here's what we're doing. And we have clients that have been, you know, very aggressive in terms of, taking our recommendations and going off and implementing them. And it not only puts you in a much more defensible position, but it also puts you in a position where the odds of being breached go down as well. Because remember, the vast majority of breaches are breaches of opportunity. No one's going after company A or company B for the most part. Occasionally that happens, but in terms of just sheer numbers, even if we go look at some of the big breaches, the Target breach, the Home Video breach, the Blue Cross Blue Shield breaches, none of those were targeted breaches. Those were breaches of opportunity. So the vast majority is not targeted. And if you have a higher wall around your moat, more than likely the bad guys are just going to go someplace else.
And we're not saying that you should spare no expense. If cost may be a consideration, especially if you're a medium-sized or smaller business, but you don't know that cost is a consideration until you have it priced. So to Mitch's point, if you say, well, we can't afford to implement all of these recommendations, we're just too small. Well, how do you know that? Did you get a quote? Because that's the first thing you'll be asked if you're sitting in a deposition, if you're sued over not implementing some of the recommendations of best practices. So again, not saying that you have to do everything that's recommended, but make sure you investigate those recommendations a little bit. And to the extent you decide that you cannot or will not implement those, maybe keep a record of your reasoning behind that.
And there may be ways that you can go implement a portion of the recommendation, right? Let's say, for example, you have an incident response program, and the incident response program says that, you need to have a crisis communications firm and a forensics firm and all these other things, and you can't afford that just because you're a small business. At least you ought to know who those firms are. You ought to go through the process of saying, okay, we know that we're going to use Fisher Phillips for this, or we know we're going to use Forensic Pursuit for forensics, or whatever we're going to go do. At least you've identified that, and that doesn't cost very much money to go do. So, these things are never black and white. There's always a degree to which you can go off and implement things. So consider that, I say that cybersecurity is like peeling an onion. And so take some of those layers and start peeling that onion. And eventually you'll get there over time, but at least you're taking positive steps in the right direction.
Danielle and Mitch, I believe time is up at this time. We were not able to get to all the questions, but we do have the questions and we do have your name. We will respond to you individually to answer your questions, so don't worry about that. Thank you all for your time. I hope you got benefit from this presentation. The presentation is now concluded.
Thank you, everybody.
Thank you.